Welcome everyone to session 10. First of all, I would like to introduce myself. My name is Anja von Rosenstiel. I'm a lecturer of law at Boston University in the US, and I'm also an attorney at law in Massachusetts, practicing attorney there, and I'm a practicing attorney in Germany with FinLaw Frankfurt. I'm delighted to present to you today consumer and investor protection in crypto asset market. These are markets which allow everyone to purchase token, to trade these tokens, to use these tokens as collateral, to lend or even to lock them up to earn yield. And the question really is whether it still makes sense to distinguish between consumer and investor protection. If you look at the European regulation of crypto asset markets under the market in crypto asset regulation MiCA, MiCA addresses only retail holders. Retail holders are defined as any natural person acting for purposes which are outside that person's trade, business, craft, or profession. This definition is the same as in the Consumer Rights Directive. So here you can see that MiCA really integrates consumer protection into the regulation. And you have already had in several sessions, you most likely as a takeaway have learned how important it is to classify tokens. So if a token classifies as security token, falls outside the scope of MiCA, you would call it either retail client or professional client. Under MiFID II, you have investor protection for both, and under Annex 2, you have a list of professional clients. But under MiCA, for the token holders who hold tokens that classify as e-money tokens, as asset reference tokens, or other tokens than EMT or ART, you have retail holders. And MiCA only refers once to consumer legislation, horizontal consumer legislation, and that is the Distant Marketing Directive. But you can say that under MiCA you have both consumer and investor protection in place. You could call this retail holder crypto consumer. And if you look at the catalog of different tools to protect retail holders, you can see that it's kind of a hybrid of consumer protection and investor protection. If you look at the access to comprehensive information, you have disclosure requirements, you know, from the capital market regulation, the so-called prospectus regulation, but you also have requirements for the form of disclosure and marketing requirements. And for retail holders under MiCA, it is important that these explanations are adequate, because you have to understand this information, and we deal with crypto asset, we deal with software, so this information has to be human readable and easily accessible. It is not enough that a software code is published and is open source and accessible by everyone. It has to be human readable, and there are certain content qualifications in place. We will talk a little later. And then a classical consumer protection tool is the right of withdrawal for other token than EMT or ART, plus the right to withdrawal under the Consumer Rights Directive, which applies here. Then you have liability for the content, for the information you disclose. The liability is much stricter than under the prospectus regulation, which means that you have external personal liability even of members of the administrative, management, or supervisory body. If you talk about crypto asset service providers, And in terms of time, the liability is unlimited. Then, if you have purchased EMT or ART and you want to redeem your tokens, you have a prohibition of fees. This is different in Europe than, for example, in the US, where under the Genius Act, regulating issuers of payment stablecoins, you only have an obligation to publish a fee schedule, but where you can actually ask for fees. Then MiCA has been drafted just after a big bankruptcy scandal in the crypto asset market. It was FTX at the time, a famous crypto asset service provider who actually went bankrupt. So MiCA makes sure that the retail holder is ring-fenced against insolvency. This means that you do not only have, like under the e-money directive, coverage of the deposit and capital requirements as with other financial institutions, but you also have to have own funds required to actually make the retail holder whole again, even in case of an insolvency. Then at the end of the day, you have a complaint handling procedure. This means that even consumer protection associations, third parties who are not party to the purchase agreement, can advocate for retail holder rights, which is very important in that regard. Again, the European regulation is really giving strong tools to enforce your rights under this regulation. But of course, consumer protection is limited in the sense that only tokens that fall under the MiCA regulation are subject to these consumer and investor protection rights. If you talk, for example, about meme coins or non-fungible tokens, these tokens do not fall under MiCA, and they don't even fall under MiFID II. So here you have only limited consumer protection. And also, if you talk about crypto asset related services, if the service provider is not authorized in Europe, you only have limited rights as a retail holder. So if we take a look at the disclosure requirement, probably the most important tool here, because it is all about enabling the retail holder to take an informed decision. MiCA very much leans on the prospectus regulation under MiFID II, which means that you have pretty similar disclosure requirements. I say that because generally you have a choice as legislator whether you want to focus on the token and the offerer or issuer of the token in terms of information, or whether you want to focus on the token and the ecosystem or the blockchain, even the infrastructure on which this token runs. These are design decisions of the legislator. This is important when we later talk about decentralized systems, but here you have very much a focus on the issuer, on the token project itself. And what do you have to disclose? Very important, you have to disclose, of course, the legal status of the offerer or issuer. You have to disclose the project's objectives. So that could be, if you deal with other tokens than EMT or ART, so-called utility tokens, which give access to services and goods. It is important to describe these services and goods, for example, or to describe the future offers, for example. Then it is important to list the risks involved with this token. For example, also to say something about volatility of this token. And last but not least, also to say something about the rights and obligations associated with the crypto asset. So here, for example, it is important to mention future offers of more tokens because this affects the price, or to say something about the modification of the rights and obligations of the token holder. So if I again take a utility token giving access to certain goods and services, and you have someone who can actually change this access or introduces certain fees, hidden fees, to access these services, all of this is very relevant information for the retail holder to have. Then, as I said before, there are content requirements. So the information disclosed has to be complete, has to be honest, has to be comprehensible, and must not be misleading. This is also very important because this is where the liability comes into play, and this liability addresses any kind of error in the white paper. And as I have already said, that this liability is not limited in time as with the prospectus regulation disclosures, and also affects members of the management or supervisory body. So this is a pretty tough liability regime. So even if the white paper obligation is kind of prospectus light, due to this liability regime, these are pretty tough requirements to meet, and especially the completeness of the information makes it a quite lengthy process. And if you look at this process of getting a white paper published and to notify the national competent authority, you can see that it is a quite complex process. And again, different from the prospectus regulation, you can see here the national competent authority does not approve, or there's no requirement to approve the white paper. The offerer has only to notify the national competent authority. And you can also see that you have like the information to disclosed in the white paper, but you also can see here the marketing communication. So this is very important that there is consistency between what you say, what you disclose in the white paper with the marketing communication in place, also the publication on the website. So there has to be consistency, and the marketing communication also falls under this liability regime. And then once the white paper is published and the NCA is notified, this notification goes to potential host member states, because you have a passporting in place under MiCA, so that you can actually offer these tokens across the EU. It is important then that other national competent authorities are informed, are notified, and also the European Security Market Agency, ESMA, is running a registry of white papers which you can access. And this again is very important. For example, if a consumer protection association wants to file a complaint, that there is an easy access to this information. If I look at the liability now for the disclosed information, as I already said, these liability obligation addresses issuers, offerers, and operators of trading platforms, and covers any kind of information that falls under the disclosure requirement. And any kind of information has to be complete, fair, and clear. And MiCA is pretty new, so we are only are getting started with a regulated market. So future liability issues may circle around the following issues. For example, the non-disclosure or obfuscation of risks. For example, the limited tradability of a token. If we talk about utility token, for example, if you cannot trade them, if you have like a reward scheme in place, this is important information for the retail holder, or the volatility of the price, for example, or termination rights of the issuer. Then I already mentioned that hidden fees or an intransparent fee schedule, especially if it's about access to goods and services, like with EMT and ART, as I already said, you have a prohibition of fees for redemption of the EMT anyway. But then again, any kind of representation that is exaggerated, or any exaggeration or a wrong representation regarding the reward schedule, or any unethical, deceptive marketing method. And as I already said, marketing communication falls under this liability regime. Also what you publish on your website. And from my practice, I think I can say that this is very important with issuers, offerers, that they learn that it really matters what they say on social medias and what they publish on their website, and that the white paper and anything that is in there is not a document you put away, but there has to be consistency. If I talk about the right of withdrawal, this right only attaches to other token than EMT and ART, meaning utility tokens. Why? Because you have already a redemption right to redeem your e-money tokens, asset reference tokens. So this would be redundant to, on top of it, attach a right of withdrawal. So if you have a utility token which is actually intended to be consumed for goods and services, you are really in the consumer protection context here, and you have this right of withdrawal. And this right only attaches to utility tokens if the utility token is not yet traded. So prior to the purchase by the retail holder. Why? Because then the retail holder is able to assess the price development of this token, and is capable to take an informed decision and does not have to have a right of withdrawal. Yes, so are we all set here, or do we have challenges that remain in a fast evolving crypto market, even if we have this comprehensive catalog of different tools to protect retail holders? Yes. Why? Because due to the composability that comes with this technology, that you can combine different kind of smart contracts, software to create a customized service or financial product, you quickly have a very complex project, which is difficult to understand. If I use an example, the Ethena stablecoin, for example, on its face, it is an e-money token because it purports to maintain a stable value by referring to the US dollar. Easy. But the retail holder has to give cryptocurrency like Ethereum as collateral to mint these stable coins, and the protocol with which the retail holder interacts then shortens the position. It basically creates a derivative to hedge against the risk of the volatility of this collateral, and in case the price of the collateral goes down, the gains of the shortened positions are used to offset the losses of the collateral. So this is a stabilization mechanism. You don't have to understand it here now, but just to give you like some insight into the complexity of such a project, in this case, the stabilization mechanism, which is not even information you have to disclose, because MiCA doesn't deal with the stabilization mechanism, only with the token. itself. So this is just to show you how complex it gets and how difficult it gets for the retail holder to still understand what actually you purchase, even if you have all the information in the white paper. And for example, there's an ongoing disclosure requirement. You do not only publish a white paper once, the completeness of the information is also meant as complete in terms of timeliness of the information, because it affects the investment decision. So if I take, for example, a decentralized stablecoin MakerDAO, what happened there is that the foundation that was actually managing the treasury of this ecosystem, like a certain amount of so-called MKR governance tokens, was dissolved, and then the network of token holders of this governance token actually became owner of this large pile of tokens. And this, for example, is a development which it has to be reported somehow, right? Because it affects the rights and obligations of the token holders of these governance tokens, which you can say are utility tokens, because the functionality is just to vote and to manage this treasury. We talk about this in session 12 in more detail, but this is something that has to be reported, and who reports this, right? And then, as I said in the beginning, the question is whether you disclose information regarding the offeror and the token, or whether there is also information that has to be disclosed in terms of the ecosystem. And here, for example, you have like a large decentralized service lending service called Aave. And there, for example, the privately held company who runs the user interface to access this service decided to distribute the fees it collects from the users of this interface to the token holders by buying back the tokens of these token holders with these fees. So this is an important information in terms of rights and obligations of the token holders. But who reports this? Who discloses this? Is this actually included in the white paper? And does the retail holder take notice of that? And so I talked already about the rights and obligations of the token holders. And often, like in the last years at least, there has been a lot of intransparency regarding the functionality, but also the rights and obligations of these token holders. So I think there are still challenges that remain, and we will see how the liability regime will deal with that to, at the end of the day, protect retail holders. One other very important tool is the authorization requirement for CASPs. So quick rerun, crypto asset service providers are defined as legal entities or undertakings which professionally provide specific crypto asset services. And they have to provide the following information to the national competent authorities. I have a whole list here. Important to remember is that I talked already about the FTX scandal. So users or retail holders usually make deposits to these centralized platforms of fiat currency, or transfer crypto assets from external wallets to these service providers. So often they have custody over these funds. So it is important that they do not commingle these funds and keep them separate. And so there has to be information in place in terms of the business model, the operations, prudential requirements. Also, the service provider, if it's a trading platform, runs an order book and has insider information or access to sensitive information. So it is about avoiding conflict of interest. And here you have, for example, information about governance arrangement, internal control mechanisms. Also, hacks are always a problem in the crypto asset market. Last year, Coinbase, one of the biggest casks, has been hacked, and important personal identifiable information of customers has been lost. So, for example, an ICT system has to be in place. Again, we have the complaint handling here. So you have a whole list of comprehensive information which the potential service provider, the applicant, has to present to the national competent authority. And if you look at this process, it's a pretty comprehensive process where the national competent authority makes sure that all the information is in place, and where you have like a back and forth of handing in the documentation, but also then again time for clarification and requests for additional information. So it is a pretty comprehensive process to make sure that you have a solid business model in place and you have an entity in place that is able to comply with all these different obligations, these tools, to make sure that retail holders are protected. But the biggest challenge really are the decentralized financial services, and MiCA. Actually touches upon this in recital 22, which is often quoted, and I read it in full here. MiCA should apply to natural and legal persons and certain other undertakings, and to the crypto asset services and activities performed, provided, or controlled directly or indirectly by them, including when part of such activities or services is performed in a decentralized manner. So what this means is either you have a centralized entity offering the service, or even if it's partially decentralized, then you still have MiCA in place. Only if you have crypto asset services that are provided in a fully decentralized manner without any intermediary, they should not fall within the scope of this regulation. So as I said in the beginning, you have strong consumer and investor protection as long as you deal with an authorized CASP in the EU. But once you deal with a fully decentralized service, there is no regulatory focal point to attach your consumer and investor protection obligations. And this is not only a problem in Europe, this also is a problem in the US. And we have currently a drafting of the market structure legislation, which hit the DeFi wall, where the question also is, if you have an innovation exemption built into hard law, and how narrow this innovation exemption is. So at the end of the day, the legislator or regulator has to balance the purpose or goal to promote innovation, to promote this technology and small startups who should not be overburdened with compliance. But on the other hand, you don't want to have the technology being able to actually go around very important investor and consumer protection rules. And also in Europe, the big question is whether MiCA should be reviewed and there should be MiCA 2.0, because at the time it was very important to come up with rules when big techs like Meta started to develop so-called asset reference tokens and to have legislation in place to regulate big tech. It was actually contemplated to do decentralized services later. And recital 22 was put then in the last moment, but it is only soft law. That means it's only guidance, but there is a certain gray area what is actually fully decentralized or only partially decentralized. And we will touch upon this in session 12 in much detail, but we will take a look how this plays a role also in terms of illicit finance in the next session. So thank you very much.